Linton.
Thank you, Chief Justice. Good afternoon, everyone. As the Chief Justice has indicated, I will be covering parts 29 to 33, which covers evidence, affidavits, miscellaneous rules about evidence, experts and assessors, and court attendance by witness depositions. The Chief Justice has noted already that we have, in advance of today's presentation, had circulated a handout which attempted to compare the CPR with the RSC. And the purpose of that was so that we would hone in on the areas of similarity and as well as areas of differences, and also where there were any new areas. And we thought that that would be very helpful, simply because, you know, the RSC is from 1978. So it's been a very long time that any of us would have really had a thorough, in-depth look at those rules. We know them by root, sorry. And so we sometimes don't even remember what's in them. And so we thought that having a handout as a takeaway would greatly assist as you prepare and look at the rules in your own time. We certainly don't intend to get a deep dive or into the weeds with today's presentation, but we will certainly do our best to provide as much information on the highlights of the various parts of the CPR. We will use the nomenclature CPR and RSC, and the PowerPoint will also be available on the website at the end of the presentation, and the Chief Justice will have it posted to the Supreme Court's judiciary's website. We are prepared to take questions as we go along on each part. We believe it might be more efficient to do so. And so if you wish to ask a question, you can either put it in the chat or you can use the raise your hand feature, and you will be able to ask the question without having to write it out. I want to also, it might be a little early, but I just want to say it in case we forget it at the end, that there will be a link with the evaluation form at the end of the presentation. So now I will get started. So if Ms. Neely, I'd be grateful if you can put up the PowerPoint presentation for me, please. Thank you. If you can go to the first slide, thank you. Right. What we've sought to do by the PowerPoint is to highlight in red the RSC provisions that are similar to the provisions in the CPR. And so you will see at part 29, which is entitled Evidence, that orders 27, 31A, 38, and 41 of the RSC has some similarities up to these provisions. Your handout will be more specific, so I didn't intend to address that here. So you can refer to your handout for those areas and where they will fit in with the CPR. But I just wish to have the slide demonstrate, you know, at the beginning of it where there is a similarity to the RSC. So starting with CPR 29.2, it addresses evidence given at trial or a hearing. And the general rule is that at trial, you give oral evidence, and at any other hearing, it's done by affidavit. And of course, there's nothing controversial or new about that. Then mode of giving evidence, which is contained at CPR 29.3. Now, I only stopped to talk about this because it talks about evidence given via video link. I mean, you can see obviously how the world has moved on from RSC 1978 to now, and even more so because of the whole COVID experience in 2020, because our rules have now talking about not in person or courtroom, but talking about giving evidence via video link. And so I just thought that that was an observation. In terms of witness statements and witness summaries, generally we are familiar with witness statements, and I believe the only reference to a witness statement might be in 31A in the case management provisions. However, the CPR has defined at CPR 29.5 the form, what is, well, at 29.4, the requirement to serve a witness statement and in fact defines a witness statement. And the 29.5 of the CPR sets out the form of witness statements, and it indicates that it must be dated, it must be signed or otherwise authenticated by the intended witness. It must give the name, the address, and the occupation of the witness. It must include a statement by the intended witness that they believe the statements of facts to be true. It should not include any matters which are not admissible, or must state the source of any matters where it is known to the witness by some other means. And it should sufficiently identify any document. Now, I want to pause there because I have seen generally the witness statements I'm familiar with do not contain exhibits. However, there are some lawyers that draft witness statements that have exhibits attached to them. And so the witness statement can contain attachments as well. Witness summaries is slightly different, and it is defined in 29.6, and it is a party who is required to provide and is not able to obtain a witness statement may serve a witness summary instead. And so you may have a witness summary in circumstances where the witness is maybe outside of the jurisdiction, or it may be for a witness that is going to be required to be subpoenaed. Of course, subpoenas now in the rules are called witness summonses. But I would like now to open up, Ms. Neely, grateful if you can open up the example of a witness summary that I would have been able to receive from the Eastern Caribbean Supreme Court. If you can scroll down so they can see the body of it. So you will see, well, first of all, if you go back to the top, Ms. Neely, you will see, everyone, that they have e-filing. And so you would see the red information there, filed in the High Court and submitted, the file, the fees paid. So that is exactly where we hope to be in the next few months. So that was e-filed. And then you will see it's a witness summary. And at the first paragraph, you would see that the claimant's name is, and so this is actually the witness summary of the claimant in this action. And she gives her evidence. And then if you can go further down, Ms. Neely. And you will see, go up for me. You will see it has a certificate of truth. Okay, and you can go back down. Thank you. I see that the information I was seeking is actually in the certificate of truth. So the claimant believes that the facts, first of all, you will see that George Lake, and I believe that he is her attorney. He says that the claimant believes that the facts stated in the witness summary are true, and the certificate is given on the claimant's instructions. And the claimant cannot give the certificate because he is currently with the West Indians women's cricket team as their coach on an overseas tour. And so she has indicated in her witness summary the reason why she is unable to do a witness statement. Okay, so that is an example of a witness summary. If you can go to the next slide, 29, 5, and 6, observation on witness right. So I have a few observations, well, one observation really about witness statements and summaries. And I've put the provisions 29.44, and I'm going to read that because at the moment, the witness statements are generally not filed. Now, I have seen witness statements that have been filed, but there is no requirement for the filing of witness statements. However, the CPR at 29.44 makes it clear the court may give directions as to the order in which witness statements are to be served and when they are to be filed. So I believe now that witness statements will need to be filed, as well as witness summaries. And so that is something that I wish to draw to your attention as a potentially new provision. And like I said, I say it in that fashion because we know that these are draft rules and subject to change. But at the moment, there appears to be a requirement to file witness statements and witness summaries. If you can go to slide 29 points, the next slide, sorry, CPR 29.7. Now, CPR 29.7 is perhaps a very interesting and maybe beneficial provision, because you can have circumstances where one party is ready to serve or exchange pursuant to an order of the court on a CMC, a case management. The court would have directed that the parties exchange witness statements on a certain date. And as sometimes happens, one party is ready to go and the other party is not. And so instead of just waiting to get to the trial and indicate, well, it can't go ahead because my learned friend did not serve me with their witness statement, and so I didn't want to serve them, we have in this rule a scenario, we have a solution to that issue. So I'm ready, so I'm the party in compliance. So I will file my witness statements in a sealed envelope, and I will give notice to the defaulting party. Then I could go down to the court. The court is not supposed to disclose the statements to the defaulting party until they have certified that they have served their own. The defaulting party would then file and serve their statements on the party in compliance, and they would provide, and again, this is, what should I say? I'm trying to propose, or I'm trying to suggest, because I don't think the rules aren't particularly clear on how notice would be given that the defaulting party has served their own statement. So I'm saying perhaps an affidavit of service or some certificate. So this is my own interjection or my own recommendation or my own suggestion on how the court, meaning the civil registry or whichever registry is affected, would know that they are able to then disclose the statements to the defaulting party, because as you see, the statements cannot be disclosed until the defaulting party has certified that they have served their own. And so obviously the court, i.e. the registry, would need to have something to demonstrate that they're now able to hand over a sealed envelope to the defaulting party. If you can go to the next slide for me, please. And what I have said here is these are really, again, my own notes on what has to be determined for the working or the workability or whatever the word may be for this provision to be of any moment and of any success for us, because this practice there's nothing quite like this practice. Of course, we have sealed files, but that's a whole different type of matter, because this is not a permanent sealing. This is a temporary sealing until you do something. So this is really not akin to even a sealed file. So again, these are my observations. This is what I'm thinking. These were my thoughts. So there's no magic to this. This is not contained in the rule. So what I have said is the court must determine the practice and procedure of acceptance of sealed envelopes. That is, who is going to provide it, the specifics of the envelope. It sounds trite, but I mean, again, you have to realize we're a court, and if you're coming in with an 11 by 17 envelope, and someone's coming in with a letter size envelope, we have to be uniform, and we have to have consistency, and we have to have a policy about what exactly is acceptable. So the information to be placed on the envelope, I am suggesting obviously the obvious things: a name of the parties to the action, the file number, the law firm, if it's the claimant or is it the defendant. The form of notice to the defaulting party needs to be addressed. So what has happened here in the form of notice to the defaulting party? The party in compliance sends a notice saying that I have filed my witness statement. So what exactly does that notice look like? Is it similar to a notice to payment into court? Again, we need to address that. How does the defaulting party certify service? Is it by some certificate or is it an affidavit of service? And of course, the court is moving away from being paper. We're looking to be a paperless court at some point in the future. And so obviously this procedure would have to be addressed when e-filing is introduced. And so my final point then is this perhaps sounds like something for a practice direction to address some of these issues. I saw in the chat Mr. McKenzie indicating something about matrimonial matters. But again, this is still very different because this is not a permanent seal. This is a seal for a time, a condition to be met, and then you actually get the sealed document. But I take the point. If you can go to the next slide for me, thank you. The remaining provisions in CPR 29 are really what I call a codification of the existing practices. And so I will just go through them, but the major change in CPR 29 was 29.7. So if you look at 29.8, witness must be called where if a party has served a witness statement or summary and wishes to rely on the evidence of that witness, the party must call the witness to give evidence unless the court otherwise orders. If your witness, if you do not intend to have that witness give evidence, if you served a witness statement and you don't intend to call that witness, you must give notice of that to the other side not less than 28 days before a trial. My experience in those kinds of matters thus far, sitting as a judge, has been that parties put in their witness statements, and then when it comes to the day of trial, you then say, well, you had 3 witnesses, and they say, no, I'm only using 2. So this is saying that you must give notice if you do not intend. You've served a witness statement and you don't intend to call that witness. So this is a marked departure from what I believe is the practice. But, maybe people do that. But, my experience has been slightly different. But if you do that, again, it's just a codification. 29.9 is amplification of evidence with permission of the court. So something has happened in between the preparation, filing, and service of your witness statement. You can certainly seek leave of the court to give that evidence. And again, that is something that I believe happens on the ground in practice. So this is really a codification of what already happens. Next slide. 2910, witnesses called at trial may be cross-examined, whether or not addressing examination in chief. 2911 may be something to consider taking a real look at, because if a witness statement or witness summary is not served in respect of an intended witness within the time specified. So you have that scenario that we just talked about in 29.7, where I'm ready, I serve the defaulting party, and they still never serve me. Then 29.11 says the witness may not be called unless the court permits. And the court may not give permission at the trial unless the party asking for permission has a good reason for not previously seeking relief under Rule 26.8. which is the relief from sanctions. And I believe that the presenters on the last occasion dealt quite deeply into this whole concept of the relief from sanctions and the need to make an application as soon as you know that you're not going to be able to comply. And so you don't sit on your hands and wait until you get to trial and say, oh, this is what happened, and I couldn't get the witness statement, and so I'm seeking an adjournment, and my learned friend has already agreed. Well, no, that is not going to happen. That's not going to fly. That's what 2911 tells us. So we're going to look now, Neely, you can go to the next slide. We're going to look at this whole concept of extension of time for service of witness statements. And I was able to find some information on it that I thought you might have found useful. At this point, I'm going to hold up two books that I used for the preparation of my presentation. One of them, both of them actually, Justice Peter Jamadar from the Caribbean Court of Justice had suggested on one of the presentations he was in, he had mentioned them. And so I would just, one is called the Commonwealth Caribbean Civil Procedure. It's the 3rd edition, but there's also a 4th edition. I did use that. And I also used the Caribbean Civil Court Practice, which is regrettably out of print. I don't know whether Mr. DeMambro intends to print some additional copies, but what I'm reading from now would be coming from the Caribbean Civil Court Practice. And so really, I think it's an interesting point because it raises where a court would consider an appropriate case to permit an extension of time for service of witness statements when you have fallen outside of your specified time. So the court will usually extend time for service. Only in very extreme cases will it exclude that party from adducing evidence at trial. Such circumstances may include the deliberate flouting of court orders or inexcusable delay, such that the only way that the court could fairly entertain the evidence would be by adjourning the trial. Now, I'm going to refer to two cases. One is John Riel versus T&T News. Okay, we'll put the books in the chat, Mr. Cunningham. The claimant had instituted proceedings for damages for libel contained in a newspaper article. At a case management hearing, the judge ordered both sides to exchange witness statements for use as evidence in chief, in default of which no evidence of witnesses would be allowed. Neither side having complied with the order, neither party was allowed by the court to adduce oral evidence at the trial. The judge, however, permitted the trial to proceed on the basis of the facts that had previously been agreed. The judge also permitted the newspaper article to be admitted into evidence, notwithstanding the fact that no witness was available through whom it could be produced. So that was an interesting one. So nobody got it, nobody complied, and they probably both tried to get an adjournment and the court didn't have it. And the case went ahead. And so that was one. And this one is where it was permitted, and I will read you this one. Again, it's very short. Glenda Edwards versus the Northwest Regional Health Authority. The defendant applied for an extension of the time for service of its witness statements. The application came up for hearing on the morning of the date set down for trial. The judge, considering and applying CPR 2673, which is very similar to our relief from sanctions, granted the application in light of the facts that the breach was unintentional and due to the theft of counsel's car, which contained her court diary. The application for relief was made immediately upon discovery of the failure to comply. There was a good explanation for the failure. The witness statement raised no new matter that would have taken the other side by surprise, and the trial date could still be kept. So again, those are two cases on this point of extension of time, because it would appear and it would seem that the inability to tender a witness statement after the time specified strikes you out. However, I just thought it was important that you be aware of those types of reasons and types of cases that support an extension of time. Ms. Neely? If you can guess. So 2912, again, that is a use of a witness statement for other purposes. I won't need to get into that one. There's nothing controversial or new about that. And I did not, I think I, in error, didn't include 2913, which was a notice to admit facts, which is our RSC 27. So moving along, before I move along, sorry, I did indicate that we would take questions. So are there any questions? in relation to CPR 29. I see a question and I'm thinking that the Chief Justice may be the correct person to respond to that one. Chief Justice? That's a question from Margaret, I believe, and I believe, yeah.
Well, let me just pull up the question.
Sure.
Is evidence by video link now going to be the norm or only in certain circumstances? Or attachments to witness statements required? Okay, on the first point, I guess I would answer it this way. And this is subject, of course, to any further practice directions issued by my successor. But at the moment, remote hearings is going to become a permanent part of our court proceedings. So I don't think when the pandemic stabilizes, we're going to go back to 100% in person. We're going to have in-person hearings. We'll have more of those than we have now. We will have hybrid hearings where the proceedings will be in person, but certain parts of it will be taken remotely. And then we'll have fully remote hearings. Is evidence by video link going to become the norm? It is subject to the discretion of the presiding judicial officer. So that's the first point. I don't know about becoming the norm, but I think it will be very usual and it will happen very frequently. Now, there may also be a distinction between local witnesses and witnesses who are outside of the country. If you're having an in-person trial and your witnesses are local, then it may well be that some of them will be required to give evidence in person. With regard to professional witnesses like doctors who have difficulty attending court, I think that's a matter for the discretion of the trial judge. Second question: are attachments to witness statements required or are they optional? Currently, they are optional. You can reference your documents without attaching them. And when I say reference your documents in the witness statements, that's a reference to the bundles of documents which you will have prior to the time when the witness statements have to be filed. So you do not have to attach them, but if you're referring to documents, they should be in the bundles. And if they're in the bundles, you should give page numbers and references. Third question: if parties are to file witness statements and summaries simultaneously, how do you know if the other party has defaulted when you go to file? Well, that's a very good question. And I think that'll have to be worked out on the ground. I mean, usually counsel are in touch with one another. And if somebody's going to be late, you would normally consult with other counsel in that regard. If for any reason the lawyers are not talking to one another, then you'll have to perhaps wait until the end of the day. And then if in doubt, you file in a sealed envelope.
Yeah.
That's the way to go, because if you file in a sealed envelope and you find out that 10 minutes after you left the registry, the other side filed their witness statement, there's no harm done. The registry will simply open the envelope and then the witness statement will be available. So you talk about it between counsel. This goes back to the overriding objective. Remember what all of the presenters have been saying: cooperation between lawyers, overriding objective. There's an obligation on lawyers and litigants to assist the court in achieving the overriding objective. So these matters should be discussed between counsel. But if in doubt, file in the sealed envelope, and then the matter will be sorted out. Back to you, Justice Galvo-Gomez.
Okay, thank you. All right, I don't know if there's any other questions. I just give it a second or two. I think, okay. Well, we'll move along now to affidavits. We can always go back, but I just thought we could stop as we go along. So let's go on to affidavits, and that's part 30. And the comparison with the RSC, again, is set out at the top of the PowerPoint. And again, I refer you to the handout that you would have received, where it would have been drilled down a lot more. And so I don't intend to get too deep here regarding the similarities. I'm just trying to highlight some of the areas that you may want to consider. So if we look at 30.1, again, this is very similar to what we have now, an application may be made for the attendance of the deponent to be cross-examined. We have a similar provision in the RSC. You would have to make the application 21 days before trial or 7 days before any other hearing. And the affidavit clearly would not be used if the deponent fails to attend so you would not be able to rely on that. Some additional new provisions contained at 30.2 and 3. An affidavit must be in a specific form. And I do have one that we will show towards the end. In the top right-hand corner and the back sheet, it must contain the name of the party on whose behalf it's been filed, the initials and the surname of the deponent, where he has multiple affidavits, the number of the affidavit, and we know that can happen. You can have a 1, 2, 3. You may even have more. Number 4, the identifying reference of each exhibit referred to in the affidavit, the date sworn, and the date filed. Now, one of the things that I'm not quite sure, and again, this is a draft, and so how this works is something that we will have to get to on the ground when the rules come in. But the identifying reference of each exhibit, I don't know whether that means we should have, if it has exhibits, for example, Merrill Glinton MG1 through MG10. I don't know if that, I mean, again, speculating that's what might be, what maybe it is referring to, but again, I'm not sure. Alterations must be initialed by both the deponent and the person before whom it was sworn. I believe at the moment that may not be a requirement to have both do it. Ms. Neely, if you can go to the next slide for me, please. If more than one document is to be exhibited, it may be included in a paginated bundle arranged chronologically or in some other convenient manner. Again, not quite sure, but I'm wondering if what is being contemplated here is a bundle of just exhibits. That's how it reads to me. And so I've put that there, an affidavit containing only exhibits. That may be what that's referring to. 30.5, the affidavit must contain the full name, address, and qualifications of the person before whom is sworn or affirmed. That is new. The statement of authentication must follow immediately from the text and not be on a separate page. I must say at this point, we do see that from time to time where the authentication is on the back, is on a separate page all by itself. And in fairness, sometimes it may not have been able to fit, but what this is saying is that you're going to need to carry over some of the body of the affidavit, and so that the authentication is not on its own on a separate page. And there's a presumption that an affidavit is sworn or affirmed in accordance with the foreign law and procedure. And I believe your handout refers to the fact that now there is a reference to the affidavit being apostilled if it's a foreign affidavit. An affidavit is sworn in a foreign jurisdiction. So if we can now take a look at the affidavit. So again, if you look in the upper right-hand corner, you'll see filed on behalf of claimant applicant. You would have the deponent, so you insert the name there. It's affidavit, you can put whether it's 1, 2, or 3, the date sworn, and the date filed. And so this reminds me a little bit of the what's required for Registrar General on documents that are to be recorded. When you record documents, you have to include that little thing in the section to say recorded in volume at pages, and all of your conveyances and documents that require recording need to have that, and then it's completed. This reminds me a little bit of that. The only other thing I would mention about this is that because there's a reference to exhibits, I believe you would have to also put exhibits as well. And you would say what exhibits MG1 to MG10, I believe you would need to also put in the upper right-hand corner. It also seems to suggest that it should not only be on the first page, it should be on the backing sheet as well. So it says that top right, CPR 32, affidavit must be in a specific form, in particular, top right-hand corner and back sheet. So it would be at the front of the document, front of the affidavit, and on the backing sheet of the affidavit. You would need to have that information. If you can go down further in this affidavit, and if you look at the bottom, it's affirmed by, at the High Court of Justice, Parliament Drive, St. John's, Antigua, this blank day of blank, in the presence of. Again, that is a new requirement in terms of the information, full name, address, and qualifications, before whom it is sworn or affirmed. Are there any questions regarding affidavits? I see it. Okay, so we will go on to part 31.
Justice Norma Gomez,
Yes,
perhaps you could just emphasize 30.5,
sure.
not 3. I mean, this is come up under the RSC, but now it's expressly stated, so you might just want to emphasize that.
Sure, I can do that, yes. If we look at, I would read CPR 30.5(3). An affidavit may not be admitted into evidence if sworn or affirmed before the attorney of the party on whose behalf it is to be used, or before any agent, partner, employee, or associate of such attorney. So practitioners practicing together, large, medium, even small law firms where you have two lawyers or more, you are not permitted to do that. Now, having said that, I believe that is the practice now, but it is expressed and it's codified in the CPR, so you can't use it. Well, I believe Margaret is asking about needing to apostille, CJ. As I indicated before, I referred to the rule. Let me refer to it because it doesn't. Let me find the provision, and maybe it's something you can address. But it says, at 30.5 sub 6, any affidavit which purports to have been sworn or affirmed in accordance with the law and procedure of any place outside the jurisdiction is presumed to have been so sworn.
Yeah, the intention is to do away with the apostille. All right, that is the intention, and that is what the rule says. In 2022, it was thought to be a somewhat anachronistic practice to require these apostilles. It may also require an amendment to the Evidence Act, so we are looking into that. But insofar as the CPR is concerned, the intention is to do away with the need for an apostille.
Are there any other questions? Okay, so we go on to 31. And this, again, is a very, very short provision in the CPR. And this one is use 31.1 is the use of plans, photographs, etc. as evidence. And if you intend to do so, if a party intends to do so, they must disclose their intention. And if they do not do so, disclose their intention to rely on that. The failure to disclose means that the evidence will not be given. And the latest date for disclosure is the same date for the service of the witness statement. So failure to disclose means failure to be able to rely upon it. Next slide, please. Evidence on questions of foreign law. And this rule sets out the procedure which must be followed by a party who intends to adduce evidence on a question of foreign law. And they would need to give every party notice of that intention, and the time frame is not less than 42 days before the hearing. And the notice will attach the document which forms the basis for the evidence, and to specify the question on which the evidence is to be adduced. Now, Chief Justice, I'm going to rely on you to, I did put that there, but I'm not quite sure if you can elucidate what the document that forms the basis of the evidence, perhaps, and the question. And the final provision in this section is evidence of consent to act as, of trustee to act. And we have an identical provision in the RSC, so I need not refer to that. This is a provision. Chief Justice, I wonder if you can assist in amplifying a little bit than what I did on this particular provision in 31.2, please.
Yes, the provision says that the notice which you have referred to must have attached a document which forms the basis of the evidence. So that logically doesn't have to be, but logically that's a draft of the affidavit of law that you would be proposing to file, and specify the question on which the evidence is to be adduced. And that is simply the question on which the expert has been asked to opine. So it is in effect a draft. I think in a practical sense, and the easiest way to comply with it is to attach a draft of the affidavit of law so that the other side has notice of it. And then, of course, that in due course would be filed.
Okay. Thank you. Any questions on this part of the CPR 31? Margaret, you sure you don't have any questions? You've been all right, so we'll go to part 32. Okay, thank you. All right, so we go to part 32. This is a bigger section. This deals with experts and assessors. And the definition of an expert is contained in 32.1. An expert, and it means an expert witness means an expert who has been instructed to prepare or give evidence for the purpose of court proceedings. Now, I want to read something that I will refer to the two texts that I'm using, and it's from the second text, the Commonwealth Caribbean Civil Procedure, that I think really explains this whole process of experts. Before the advent of the CPR, the reality was very different. Really what they were talking about, anyhow, I'll read it and I believe it'll become very clear what I'm talking about. Before the advent of the CPR, an American commentator had this to say: the idea is that the lawyer plays the tune, manipulating the expert as though he were a musical instrument on which the lawyer sounds the desired notes. I have experienced subtle pressures to, quote unquote, join the team, to shade one's views, to conceal doubt, to overstate nuance, to downplay weak aspects of the case that one has been hired to bolster. The result is our familiar battle of experts. The more measured and impartial an expert, the less likely he is to be used by the other side. The CPR has attempted to remedy this state of affairs by expressly providing inter alia that an expert witness must give independent assistance to the court by way of objective, unbiased opinion in relation to matters within his sphere of expertise, and that where two parties wish to submit expert evidence, the court may direct that evidence should be given by a single expert witness. I must say that that pretty much sums up the provision in Part 32, that the expert is there to assist the court and not to bolster anyone's case. Expert evidence, and I'm referring to 32.2, must be restricted to that which is reasonably required to resolve the proceedings justly, and the overriding duty to the court, which I just read about, which is to help the court impartially. So if we look at 32.4, the expert's duty to the court is to be carried out. Again, I just referred to that. If you look at the CPR 32.5, an expert has the right to apply to the court for directions. And an expert who applies for directions need not give notice of the application to any party. The court may direct that notice of an application be given to any party, and a copy of the application and any directions given be sent to any party. At 32.6, Ms. Neely, you may move along. You must name the expert. Now, this is a new departure from the existing practice. On a CMC, a case management conference, usually, you tick the box. Do you need an expert? Yes, no, maybe, yeah, I might need an expert. However, when you say that you need an expert, under the CPR, you must name the expert witness and identify the nature of the expertise. So permission now is not for an expert. The permission now is for a named expert. So, oh, I'm going to need an orthopedic surgeon, and I'm going to need a no. You would have to name your expert. So it's a very different scenario under the CPR than exists under the RSC. A party may put written questions to a joint expert or to the other party expert about their report. But note, the questions put in, we can only put the questions in once, and they must be put in within 28 days of service of the report. CPR 32.9, the passage I just read to you highlights the power of the court to direct evidence by a single expert. The claimant may want one, the defendant may want one, and the court says no. You have one. And there is a provision that I need to refer you to in 32, I believe it's 32.9. Let me see. Right. I'm going to read it. I think it's something that you should be aware of. 32.9. I've already said if two or more parties wish to submit expert evidence on a particular issue, the court may direct that expert evidence be given by one expert witness. If the instructing parties cannot agree on who should be the expert witness, the court may select the expert witness from a list prepared or identified by the instructing parties. Okay, so claimant, defendant, we can't agree. We come up with a list. The judge takes a look at it and say, okay, this is going to be the expert. Okay, so that's how the judge gets to part that fight. Everyone puts their list together and the judge makes a selection from a list that's compared by both instructing parties. Okay, the cross-examination, I've already dealt with 32.9. An expert may be cross-examined by any party is at 32.10. 32.11, instructions to be shared. Instructions may be given by each instructing party where there's a single expert. So now what has happened is the court has said, you don't get two, you get one expert. And so claimant and defendant must share the instructions that they are giving to the expert. And I believe there's a provision that there's a penalty if you do not share. And let me point that out as well, because that's worth noting. Right, when an instructing party gives instructions, this is 3211 sub 2. When an instructing party gives instructions to the expert witness, the party must at the same time send a copy of the instructions to the other instructing parties. There is a sanction that I must have read it in the, and I think I may have read it in one of the books that I referred you to, but there is a sanction if you fail to share your instructions that you are giving to the expert, where there's a single expert. I don't see it now, and in the interest of time, I will move along, but it is an important thing to be aware of. So you don't have your own, everyone's sharing, and so everyone has to share the instructions that they are giving. Now 32.12, I must admit, I've put beware there, and I'm going to have to ask the Chief Justice to assist because this seems, well, it is new, but it also seems to be, I'm not quite sure if there's a justification for this particular provision. And so I will leave it to him to explain it if he can, but I will certainly, I believe it is worth highlighting. So I'm going to actually read it exactly as it is here. If a party has access to information which is not reasonably available to the other party, the court may order that party to arrange for an expert witness to prepare a report on any matter. If appropriate, to arrange for an examination to be carried out in relation to that matter, and to file the report and serve a copy on any other party. The court's powers under this rule may be exercised only on the application of a party. Chief Justice, I don't know if you are able to at this time or you wish to do so later, but that provision sounded rather onerous. It sounded, I'm not quite sure what was the thought there, but I think it's something that may require a little bit more explanation that I don't believe that I may be the best to share at this time. So I can complete and come back to that. But I did think that it was something, but notice in particular that it's only exercisable upon application by a party. So there is no, the parties would be heard if the court decides to exercise its discretion. However, the point that the court has the discretion to exercise and what that means to a party, I think may be worth highlighting. 3213, oh, sorry, Chief Justice, I can stop here if you wish to do so.
No, I was only going to say that I think an example of this is where perhaps one party, say in a personal injury case or professional malpractice case, if one party has information which is solely in the possession of that one party, and for some reason it hasn't come out during the disclosure process, it does seem to me to be a power which the court has in order to compel that party to allow an expert witness access to that information and to prepare a report on any matter which might be issued. There are other cases where it might be used, and if other participants have any ideas on it, you could perhaps put it in the chat group, or you might want to address it later on. But again, this underlies the element of cooperation that is expected under the CPR between the parties. And if one side has evidence or information which it is not providing to the other side, and the other side needs it in order to produce an expert's report, the court can compel that party to provide that information. I think that's the essence of it, but let's see if anybody else has any further thoughts that chat group.
Okay.
I actually would have had a case where this would have been relevant, and it was a trust case in which the claimants were beneficiaries of a trust, and the two defendants were trustees. But in the circumstances, one of the defendants was a more managing trustee, and another defendant was a bank trustee. So that the bank was privy to certain financial information which the beneficiaries would definitely not have had, and which the managing trustee said that they could not make certain statements unless certain information was released from the banking trustee. So that was a scenario where, in order to deal with a preliminary issue and to even allow the claimant to help formulate or limit perhaps some of its potential claims, it was necessary to get an element of report while also recognizing that they weren't entitled to have the full financial documents because of the nature of the trust itself.
Thank you. Thank you. Okay, so yeah, I just think it's important for areas that appear to be not similar or just totally new, that you know, we highlight them so you can make sure take a look at them, because it's really only through going through them that you'll really be able to see exactly how it impacts you on a personal level. So that may be good for some people to be aware of that provision. And so I just thought that I should point that out. And 3213 is that the expert's report should be addressed to the court and not to the instructing party. 3214 sets out what the contents of a report ought to look like. It gives the details of the qualifications of the expert, the details of any literature or other material which the expert witness has used in making the report. It would say who carried out any test or experiment which the expert used for the report, give the details of the qualifications of the person who might have carried that out. And you know, that there is, like I said, that I don't need to read all of it, but it's in CPR 3214. And it's quite extensive in what ought to be addressed. 3215 is again another new provision. It sets out what is called a meeting of the expert. And this is something that would be directed by the court. And the court would specify the issues which they need the expert witnesses to discuss. The content of the discussions would not be referred to at the trial unless they agree to that. However, after the meeting, because the meeting has been convened because the court has requested an opinion on issues for them. And so they would then, at the end of the meeting, they would prepare for the court a statement of any issue within their expertise, and they would either agree or they would disagree, and they would give their reasons for it. Okay, so that is a new provision as well. And 3216, I think I must have missed it out. Consequences of a failure to disclose an expert report. And we all know what happens there based on the overriding objective. If you fail to disclose, then you cannot rely. So you fail to disclose the expert's report, you cannot use the report at trial or call the expert witness unless the court gives permission. And the court may not give permission at the trial unless the party asking for permission can show that it was not reasonably practicable to have applied for relief at an earlier stage. So again, we look at those sanctions that are contained in CPR 26.8. And I want to just refer back to them because there is a lot of reference to 26.8. And for those that would not have participated or attended the presentation last week would not necessarily be aware of them. And so 26.8 is relief from sanctions. And I'll just read briefly what it's all about. On an application for relief from any sanction imposed for a failure to comply with a rule, practice, direction, or court order, the court will consider all the circumstances of the case so as to enable it to deal justly with the application, including the need for litigation to be conducted efficiently and at proportionate cost, and to enforce compliance with rules, practice, directions, and orders. And the application for relief must be supported by evidence. Okay, and of course, there may also be court sanctions. So that is important to note, that failure to comply, the sanction provisions are contained in 26.8, and they're pretty much similar to what happens now. You know, maybe an order for wasted costs or things of that nature, or it may just be that you are not going to be able to rely unless you can show good reason. And I would have read two cases where in one instance, the judge said, neither party has complied with my order to exchange witness statements, and therefore no one gets to rely on the witness statements. And in the other one, the court made a decision in the opposite direction. So the final provision in 3217, they were not new, which is why they were not included. And that's probably why I didn't have them on a slide. 3216 and 3217 aren't really new, but I just want to refer to them because they're the last two in that CPR rule. The appointment of an assessor. And the court may appoint an assessor to advise the judge at trial with regard to evidence of expert witnesses called by the parties. And they would assist the court in understanding the technical evidence or only provide a written report. So again, that's in 3217 of the CPR. I will stop there. I don't know if Ms. Clinton, you have anything that you wish to highlight? I should have asked you sooner on anything that I've indicated. And if there are any questions or the Chief Justice wants to make any additional comments before we move on to my final part.
And nothing from me.
Miss Margaret, is there anything from you or anybody else in the virtual world, in the virtual room? Because I can't see anyone. I don't know if there are any other questions. Either everyone's gone home or is doing something else, or hopefully they're understanding. Okay, Chief Justice, nothing further from you before I go to my final part?
No.
Okay, all right. So part 33, which is court attendances by witnesses and depositions. Now, this part provides for a party to obtain evidence prior to a hearing, including a trial, and for circumstances where a person may be required to attend court to give evidence or produce a document. So everyone knows the subpoena. There is no subpoena. There is a subpoena, but the nomenclature subpoena has left us. So we now use the term witness summonses. If you can go to the next slide, right. So it would be issued by the court, compelling a witness to attend court or give evidence or produce a document. Now it's very early days. And so, I don't believe any form had been attached to the rules. And the Chief Justice will correct me if I'm wrong, but I can only speak to the existing situation regarding subpoenas. And as we know, the subpoenas are signed by the registrar. So I'm not quite sure, Chief Justice, if there's any, well, I guess it might be early, so I won't necessarily raise it, but the witness summonses, if they're similar to what the subpoena process, we know that the registrar signs off on the subpoena. So whether that remains, I guess we will see when the forms come out, and if you don't know that at this time. Each witness must have a separate summons. And I must say, in my days as registrar, I would have seen subpoenas with 10 names on it. And so this makes it very clear that each witness must have a separate summons, even if they all happen to work at the same place. They must each have their own summons. Now, a new provision that's worth talking about is the fact that the court may issue a witness summons in aid of any court or tribunal which does not have power to issue one in relation to proceedings before it. What comes to mind here, and the Chief Justice can correct me and perhaps suggest others or Ms. Clinton, would be arbitrators. In an arbitration proceeding, the arbitrator has no power to do that. And so I believe this might have been contemplated in CPR 33.4. CPR 33.5, the general rule is that a witness summons is binding only if it is served at least 14 days before the witness is required to attend unless the court otherwise directs. So again, it would be interesting to know how this procedure will be, whether this would be, again, a requirement for a registrar to sign the subpoena as the witness summons as they do for subpoenas now, and what exactly is the procedure. Because if you have 14 days, you may have a trial date may be hinging on the service of a witness summons. And so it would be important to know, Chief Justice, how these witness summonses are to be issued. Are they issued in a similar process that exists now, or is there going to be a different process? Because if the clock is ticking, then that would matter. The 33.6, at the time of service of the witness summons, the witness must be offered or paid a reasonably sufficient sum to cover subsistence and travel expenses to and from court. And that is to be specified in a practice direction. And I don't recall at the moment, but I think there might, well, it says new, but there is a provision in the RSC. I'm not sure if it's express or that's just maybe something that we would have inherited from the white book, but there's something we call at the moment conduct money. This reminds me of that scenario in terms of compelling a witness to attend and being liable for what is termed now conduct money. CPR 33.7, travel expenses must be offered at the time of service of the order. So that's that part. I think my slide may have been missing some provisions on the deposition. I think I might have cut it off. So let me, if we go to 33.7, actually that's the wrong reference. It was 33.6, but 33.7 deals with evidence by deposition before an examiner. And an order under this rule shall be for a deponent to be examined on oath before a judge, an attorney who has practiced for at least 5 years, a magistrate or a registrar, or but the order must state the date, time, and place of the examination and the name of the examiner. I know that at the moment we would see some of these in the Attorney General's office would send over, I know as registrar, I would have seen them. I don't remember. Ms. Clinton, you remember where we would have seen them? These depositions, you would see them in foreign proceedings, a deposition taken in foreign proceedings in particular.
Yes, usually in foreign proceedings, I would say.
Yeah, we see them. They're more common in those types of proceedings, but there is provisions for them in the CPR as well. The CPR speaks about the conduct of the examination, the enforcing of attendance of a witness, and also the fees and expenses and the payment of those expenses. So those are all contained as well in 33. The reason I did not make them a big part of the slide was simply because they are very similar. Those provisions are very similar to what is in the RSC. And so today's presentation was really more to highlight those provisions that were different or that were new. And so that is why there's not much information regarding depositions. Is there anything further you would wish to comment on, Ms. Clinton or Chief Justice, before we go to any questions?
No comment from me.
Yes, Ms. Johnson Hassan has made a comment in the chat. And then there is a question, how do you deal with a subpoena for a witness? And a subpoena is now called a witness summons. And the witness summons process, how it is actually issued, is not addressed in the rules. Let me refer to it. It just says a witness summons is a document issued by the court requiring a witness to attend court. This is 33.2, CPR 33.2. It must be in Form 12, so there is a form, and there must be a separate witness summons for each witness. A witness summons may require a witness to produce documents to the court, either on the date fixed for the trial or at the hearing of any application in the proceedings, or any other date that the court may direct. Now, at 33.3, it tells us about the issuance of it. It is issued on the date entered on the summons by the court office. A party must obtain permission from the court when that party wishes to have a witness summons issued less than 21 days before the date of the hearing. An application, so if you're not able to have it issued less, if you need to issue it less than 21 days before the hearing, you would need to get permission from the court. There is going to be a form because it refers to a Form 12. The summons will be in a Form 12, and I don't believe we've been given the forms just yet, and so that will be something that we would have to see. But it is issued by the court. So I don't know if there are any, is there any other? I was just looking back at that question. How do you deal with the subpoena? That's as much as I can answer it with reference to the CPR. Chief Justice, there is also a question, forms, when we be able to see the forms in order to familiarize ourselves. So I will leave that for you to address, and anything else that you wish to do so.
Well, the forms are being prepared now. We've subcontracted someone to do that for us. I'm expecting to have the first draft of all these forms by the middle of this month. So we'll see whether we get them, but they should certainly come out before the end of the month.
Well, Chief Justice, that completes my parts. I was 29 to 33, and I have completed my parts. There were no, any questions can come later if people wish to wait to do so, but until such time, I'll stand down for Ms. Clinton.
All right, thank you very much. I invite you, Ms. Clinton, to make your presentation now.
Good evening, all. So I have been asked to address parts 35 through 41, and those parts deal with offers to settle, payments into court, discontinuance, pretrial review, trial, and appointment of a referee to inquire and report. If you've had an opportunity to go through the training handout or have looked at the rules themselves, you'll probably be able to see that parts 35 and 36 are going to be the bulk of my time here today, as they are the parts which are most new. So beginning with part 35, offers to settle. So there's no equivalent provision in the RSC in terms of an order that sets out or addresses offers to settle in a general way. But there are provisions in the RSC which kind of give you a highlight of the spirit of what Part 35 is intending to do. And in general, of course, even under the RSC, settlement and offers to settle were generally encouraged between the parties. In the handout, I would have isolated a few parts of the RSC to which you might want to draw your attention, just to get a flavor of how these two, the CPR and the RSC, are still going towards the same objectives. But I will draw your attention particularly to Order 16, Rule 10, which Order 16 is addressed towards third-party notices. So this particular provision is only available to third parties and joint tortfeasors. But it provided a means by which a third party who anticipated that they might need to make a contribution towards damages of any other party, to make that party a without prejudice offer, which would not be drawn to the attention of the court, and which the court would, pursuant to Order 59, Rule 5, be able to take into consideration when it was making its determination on costs at a later event. So this is the idea behind Part 35, that we are encouraging parties to make offers, and that in doing so, there can be consequences as a result of making and accepting or not accepting that offer. So 35.1 sets out the scope of this part in general, so that this part addresses without prejudice offers, as well as the consequences, as I said, of accepting an offer or refusing an offer. It also preserves the right of parties to make offers otherwise than under this part. And that is because you will come to see later, there are certain deadlines which must be met and certain requirements which must be met to come within the scope of this part. So do not think that this is now the only means by which you can make an offer to another party. Before I move on, just to mention as well, anyone who would have trained in Part 36 under the English CPR, this will feel familiar to you, but I want you to read it very carefully because it is not identical to Part 36 at all. Moving on to 35.1, the limitation within 35.1. It expressly carves out and refers you back to 23.12. And that provision is specific to compromises on behalf of minors and patients. So in reading this part, if your client or if the person to whom you might be making an offer is a minor or a patient, you are going to want to look at 23.12 before you even come here, because it sets out some special provisions for that. Also highlighted here, just to let you know, in the next section, we will deal with payments into court, but some of that will be referenced here. But if you see that come up, just know that we will get into more detail on that next. If I can go to the next slide. So, as I would have indicated, the idea here is that a party can make an offer. That offer is to be marked as being without prejudice, and the offer is not to be drawn to the attention of the court until after the court has made a determination on the liability of the parties. But generally, 35.2 gives us some terms that you would want to be familiar with because they're used throughout this part. The party who extends an offer is an offerer. The party to whom an offer is extended is an offeree. And an offer is only deemed to be made when it is served on the offeree. An offer can be made whether or not the claim is for money or liquidated damages. So even if you have circumstances where what you're seeking is perhaps restitution or specific performance, you can still make an offer pursuant to this part, and you can still take advantage of some of the benefits or be subject to some of the consequences that come as a result of the making of that offer. Next slide. Now I'm drawing your attention to 35.3 specifically because I would have already said to you the general idea here, which is that you make the offer without prejudice. In 35.1, and I will perhaps kick it to the Chief Justice to say if I'm right about this, but It says a party may make an offer to another party which is expressed to be without prejudice, and in which the offerer reserves the right to make the terms of the offer known to the court after judgment is given with regard to the allocation of costs of the proceedings, and in the case of an offer by the claimant, the question of interest on damages. When I first read this rule, I thought that it was saying that you couldn't make the offer known until the court had already given judgment on costs and interest. But just to make very clear, and I think that when we get to 35.5, I think it is later, they clarify this. The idea here is that the offerer in its offer might take account of costs and interests, but they also are capable of making an offer which does not expressly deal with those two provisions. They can make an offer solely on the claim itself or damages if there are damages involved. Also, an offer can relate to the whole of the proceedings or to any part of the proceedings or any singular claim within a larger claim. So you don't necessarily have to make an offer to settle the whole thing. You might say, listen, there's one part of this that I will accept liability for, and so I will make an offer only in relation to that part. Next slide. A party can make an offer at any time, even before the beginning of trial, and that's going to become important when we look at the consequences later, because certain things flow from the timing of the making of the offer. And this ability to bring yourself within this part of the rule, even if you don't have a claim already commenced, might assist you as a claimant or a defendant making the offer. As to what the offer, the procedure for making an offer, that is found in 35.5. An offer must be in writing. It must be served on all other parties to the litigation. So in certain circumstances, you might want to make an offer to a party and not necessarily have the other parties be aware of the full terms of that offer. In that case, you will not be able to come within the scope of this part. But again, as we earlier indicated, that does not mean that you're not still capable of making an offer outside of this part. Also, the offer should generally not be communicated to the court until after the court has made its final determination, which we indicated earlier. But the exception to that is, of course, where an offer has been accepted. At the time that the offer is accepted, then the court can be brought into play, and in fact will have to be alerted to it for reasons which will become clear later. And also, if the defendant is raising a defense of tender, then of course, in those circumstances, the court will already be aware that the defendant would have offered some money to the claimant. Next slide. So any offer that is extended, and remembering that the offer must be in writing, must state whether or not the offer itself includes costs and interests. And if you want that offer to include cost and interest, you must also detail exactly how much of what you are offering. And in this circumstance, we're speaking specifically of offers in relation to claims for damages. So in those circumstances, you must separate how much of the amount that you're offering is set aside for the damages itself, and how much has been set aside for costs, and how much has been set aside for interest. If there is a counterclaim, then a claimant offerer must indicate whether or not the amount that's being put forward is also taking account of the counterclaim, and a defendant offerer must determine whether or not this amount is also taking account of the claim as well as the defendant's counterclaim. Also, if any interim payment has been made during the course of proceedings or during prior to commencement of proceedings, you must indicate whether or not this amount that you are offering is going to be paid in addition to what was already paid, or whether that includes any amounts that have already been paid. Next slide, please. The offer must state whether or not it covers the whole or part of the claim. So earlier we would have given the scenario where you might admit liability on one part, but not another. You will have to clearly state exactly which claim this offer relates to, in addition to how much you are assigning to each part of the claim. If, for example, you're making an offer on multiple parts, but not all of the claim. This will again be very important later when you look at how consequences apply. If you do not state that it is covering only part of the claim, then it will be taken to be in relation to the whole claim, which can be detrimental to you, as you will come to see later. This is also important because certain things will follow automatically on the acceptance of an offer. So all of these details will need to be set out in the offer itself in order to not potentially undermine any remaining claims that might need to still be considered by the court or go towards the court. If I can have the next slide, please. $35.9 deals with the timeline for accepting an offer. So a party may choose to put a deadline for the acceptance of an offer, or they may choose to leave that offer open. However, if you want your offer to fall within the provisions of this part, then your offer must be served on the party to whom the offer is made at least 22 days prior to the commencement of trial. And it must be open for acceptance in any event for at least 21 days. Acceptance of the offer after the commencement of trial will have no effect on the decision that the court makes as to the consequences of acceptance. But a court can permit a party to accept an offer after the deadline has expired on such terms as the court deems to be just. So the importance of some of these provisions will be more apparent when we get into the consequences of either accepting an offer or refusing a reasonable offer. But you will note again that here there's an emphasis on the trial date. So what the CPR is really trying to get parties to do is to consider seriously settlement before trial, because as we all know, certain amount of costs and particularly time and resources of the court are expended more once you get into trial. Next slide. At 3510, we deal with the procedure for accepting an offer. In order to accept an offer, acceptance must be by a written notice of acceptance, and it is deemed to be accepted when it is served on the offering party. A copy of that notice of acceptance must also be sent to all other parties. I will remind you here of the provisions under 23.12 because acceptance becomes a slightly different issue in the case of a minor or a patient, in that the court must give permission prior to acceptance of an offer, and any offer is not deemed to be accepted until the court gives its permission. Also, as we'll come to see later, in terms of getting paid out any sums which might have been paid into court to support the offer, that also requires permission in circumstances of a minor or a patient. Next slide. So now we're going to look at what the effect of accepting an offer will be. And 3511 deals with the general rule, and this is particularly in relation to two-party litigation, so where there's a single claimant and a single defendant. The circumstances become a little bit different when there are multiple parties, and we'll address that a bit later on. But for now, we're looking at the general rule. So the general rule is that in accepting an offer, an automatic stay will apply. Now, if you accept an offer which deals with the entirety of the claim, then the entire action will be stayed. However, you can accept an offer in relation to only part or parts of the claim, in which case the stay will only apply to that part on which the offer has been accepted. And the same is the case if an offer is accepted perhaps in relation only to a claim, but not a counterclaim, or vice versa, only the claim or counterclaim which has been settled will be stayed. However, that stay does not affect everything. So firstly, if you are acting in circumstances where you require the court's permission, and we would have identified earlier some circumstances where permission is needed, the stay does not apply until the court actually grants permission. So if you are, for example, in case management, and remembering what Justice Darville Gomez would have highlighted to you earlier, you should continue with your case management until such time as the court actually accepts the offer and gives permission for acceptance of the offer, because you won't be able to rely on this idea that you thought that it would be accepted in your not complying with any case management, which might need to happen in the meantime. Also, if the offer, for example, was exclusive of costs and interests, and you require the court to deal with that, or in the case of offers only as to part of the claim where the court must deal with the costs, the stay does not apply until, or does not apply to your ability to apply to the court to address those matters. And also doesn't affect any payment out that you might want to get if monies have been paid into court in support of the offer. Some of these things that I'm saying, for example, like money in support of an offer, we will deal with in the next part. So don't feel as though you should be familiar with that yet. Next slide. This part is actually going to be very helpful, I think, to some of you, anyone who has represented a party where it was believed that they were agreed and a settlement was in place, but there was a breach of the settlement agreement, will know why this can be particularly helpful. If a party fails to comply with the terms of the accepted offer, then the stay is automatically lifted. There's no need to apply to lift the stay. And the proceedings on that part of the claim to which the stay was in place and which the terms of the offer related to, those proceedings can either now continue or the party can apply to the court to enforce the terms of the settlement agreement. Also, if a party suffers damages for breach of contract arising from a failure to comply with the terms of an agreed offer, then that party can now apply to the court to assess those damages without having to start a new action on the settlement agreement itself. Next slide. So 35.12 covers 3 specific scenarios which we will have to look at very carefully. In fact, I think even the training handout might not go into great detail or as much detail on this as I'm about to, because it was only in reading these parts a few times that I was able to see why they are different. So the first circumstance which is covered under 35.12 is in 35.12 sub 1. And I have the rule in the slide, particularly for this one, and I will read it. It says, if there is more than one defendant whom the claimant claims are jointly and severally or severally liable to the claimant, then, and certain things follow from that. But I want to draw your attention specifically to the jointly and severally or severally liable. that is the distinction between this subrule and the subrule that comes next. And you're going to want to pay attention to what the nature of the liability is, because the cost repercussions will be dependent on whether or not the liability for that particular part of the claim is a joint and several liability, or a several liability, or a merely joint liability. And each part of a claim might have a different kind of liability to which attaches to it. So you'll really want to look at that when you before you discuss even making an offer with your client, because they'll need to know what those repercussions might be. So where there are more than one defendant, and those defendants are either jointly or severally liable, or jointly and severally liable, or simply severally liable, in circumstances where a claimant accepts an offer and then from one of those defendants, and then chooses to discontinue the claim against any other defendant, then the claimant is going to be generally liable for the costs of the defendants against whom they have discontinued their claim. Now, this might seem strange, but when you consider the implications of joint and several liability and several liability as opposed to joint liability, you will understand why this rule works this way. In circumstances of joint and several liability or several liability, a defendant might say to you, listen, I'm only really responsible for this portion of the damage that you're claiming. So I'm prepared to pay my portion. But because the liability is joint and several or several, in theory, a claimant in this circumstances could still continue the action against the other defendants. So that if you discontinue against those defendants, this is really costs following the event. This is you saying that I'm going to accept only what this defendant is offering me, and I'm not going to pursue the claims against these other defendants anymore, even though at law I'm able to. So this is one where particularly the claimant will need to be careful as to what it considers when accepting an offer and whether or not it decides to discontinue the claims as against the other defendants at that time. If I can have the next slide. So 35.12 sub 2 also addresses acceptance of an offer by a claimant in circumstances where there are multiple defendants. But in this circumstance, this is where the defendant's liability is joint only. And in that circumstance, paragraph 1 does not apply, and the defendant who makes the offer becomes liable to the costs of the other joint defendants. And if you know how joint liability works, in these circumstances, think about, for example, a partnership. You're looking at one whole claim for damages, but they are jointly liable because they are partners. So the one person making the offer is making an offer in respect of the total damage. And the idea is that because they were jointly liable, this is again kind of costs following the event. If you take it upon yourself to say, I'm going to take on this liability, then you also become responsible for the other defendant who, in theory, should not have been there. Moving on to 35.12 sub 3, in circumstances where there is more than one claimant, in circumstances where there is more than one claimant and one of them wants to settle, or multiple of them, but not all of them want to settle, then this only carves out permission for any remaining claimants who don't accept the offer to continue the proceedings, notwithstanding that one claimant has settled. Some of this might feel a bit clear as mud right now, and I promise you that if you spend time with this part, it does become more comfortable, but I do emphasize you to really pay attention to the particular words of each part, because there are very precise consequences and effects that come into play for very precise situations and scenarios. If I can have the next slide. Okay, so now we're at 35.13, and this addresses costs where a defendant's offer is accepted. So in this part, remember that the basis of this is that a defendant has made an offer to a claimant and the claimant has accepted that offer. And particularly, the claimant has accepted the offer within the period stated for acceptance, or if there is no period indicated that they have accepted the offer before trial. In that circumstance, generally, a claimant is entitled to the costs of the proceedings up to the date that they accept the offer. That's kind of the most straightforward scenario. And because the claimant has accepted the offer, it's generally a restatement of, again, costs following the event. Now, if the defendant permits a claimant to accept an offer after the time in which they indicated the offer must be accepted, then the general rule becomes a bit different. And this is where we start to see some consequences, or I guess in the case of the person who's offering, or in this circumstance, the offering defendant, you will come to see some benefits to making an offer under this part. So if a defendant says, I'm going to offer you that we can settle this matter for X amount of money, but you only have 21 days, and remember 21 days is the minimum amount of time that you can leave the offer open if you want it to fall under this part. So if they say you have 21 days to accept this offer, and the claimant does not accept the offer within the 21 days, but they accept the offer sometime later, then the claimant will be entitled to their costs up till the end of that 21-day period. But after that 21-day period, the defendant will be entitled to have their costs paid by the claimant. And again, the spirit of this is to encourage parties to really consider an offer when it's made to you, knowing then that if we go beyond that point, beyond the period in which this offer is open, you could be risking some cost consequences to yourself. Now you will see that it carves out that this is unless the court otherwise orders. Know that this part does not really limit or impede upon the court's general discretion as to costs. So there is potential for these consequences not to apply, but you will have to explain to the court why it is you would say that this general rule should not apply. Next slide. So now we have the same scenario, but this is where a defendant's offer is accepted, but the offer relates only to a part of the claim rather than to the entirety of the claim. In that circumstances, the remaining claims, remember that where an offer is accepted on part of the claim, those parts are now stayed. But the remaining parts of the claim are still going to go on for trial unless they are later settled. And in those circumstances, your costs will not be recoverable or quantifiable. That is to say, they will not be payable or, as we think of it now, taxable or assessable until after the remaining claims have been dealt with by the court. And the reason for this is because, of course, the court is going to need to consider apportioning how much of this claim was, or how much of what was done here, or the monies expended by these parties related to that part which was settled, that part which continued, and the relative importance of those things. It also acts to protect a defendant who wants to make an offer and who might be wants to put their costs in order and to stop time running on that issue, but who may not want to have to pay those costs over because they might because they might themselves be entitled to some damages either on a counterclaim or on other parts of the claim, or they want to see how the costs fall in relation to those parts of the claim which continue. Next slide. And of course, the final scenario is costs in which a claimant's offer is accepted. So if the claimant makes an offer which is accepted by the defendant, then the claimant is entitled to costs up until the time when notice of acceptance of the offer is served on them. You will notice here perhaps that there's, of course, no heavier burden for acceptance after the time in which an offer might have been said to be available. And that's because if a defendant is accepting the offer, costs following the event is the usual. And so the defendant will have to pay the claimant's costs generally up until any time that they accept the offer. But do remember that there are some other consequences coming later. If an offer is not accepted, things become a bit more tricky. Next slide. So now is where we deal with costs where an offer is not accepted. And this is where you will really start to see some of the benefits for an offering party and some of the consequences for a party who does not give proper consideration to a reasonable offer. 35.15 is a really heavy hitter rule, and I would advise you all to spend some serious time with it. Remember that none of this will come to the court's attention until after there is a final determination on judgment. And that will make sense to you when you see how these consequences come into play. It addresses circumstances where a claimant does not accept a defendant's offer, circumstances where a defendant does not accept a claimant's offer, and also some exceptional circumstances. Next slide. So 35.15(1) addresses the circumstances where a defendant makes an offer to a claimant and the claimant refuses the offer. So keep that in your mind as we're going through these next portions, because that's the foundational idea, right? So these are the consequences which will come to play. And remembering now that this part applies not only to settlements which relate to damages, but also to any other case. So in this particular scenario, consequences will apply in the case of where there's a claim for damages. If the court ends up awarding the claimant less than 90% of what the defendant offered by way of damages in damages claims, then there will be consequences for that claimant. And some of you might be wondering why 90%. And I know that was something that we had talked about even in our rule committee meetings. I'm going to come back to that point in a moment because you will see it and it will be more emphasized when you look at the alternate to this provision. And I will give you my ideas as to why this operates this way. And I will, of course, invite the Chief Justice and her ladyship to also give their comments. In cases where an offer is made by a defendant, which is refused by a claimant, and where damages is not the subject matter, so in any other case where we're not dealing with damages, there can still be consequences if the court considers that the claimant acted unreasonably in not accepting the defendant's offer. Now we're going to look at what those consequences will be in both of those scenarios. In those scenarios, a claimant will have to pay any assessed costs incurred by the defendant after the latest date on which they could have accepted the offer without the court's permission. So, by way of example, just to give you an easy way of thinking of this thing, if I am a defendant and I offer a claimant $5,000 to settle the action, if the court ends up awarding less than, in that case, $4,950, then after the date at which the claimant could have accepted that offer, any costs which I incurred, they will have to pay to me, even though technically they were successful in their claim. I'm hoping that I was able to verbally communicate that in a way that makes sense. And in the other scenarios in which there's no damages, let's say that I make an offer to you to say, listen, we're arguing over this painting. I'm prepared to turn it over to you under certain conditions. And the claimant comes back and says, I'm not going to accept these conditions, so no, I'm not accepting the offer. If at the end, when the court makes its decision, even if the court determined more in the claimant's favor than mine, if the court then is alerted to the offer and the court believes that the claimant was unreasonable in accepting the offer, then the claimant will have to pay my costs from the point when they were able to, the end of the point where they could have accepted my offer without the court's permission. So if I set a timeline, the end of that timeline, or in any other circumstances, the trial date. Next slide. So now we will deal with where the claimant makes an offer and the defendant refuses it. Now, there are two different scenarios which might come into play in this situation. And this is where I said you might start thinking about why it is 90% in the alternate to this. But in circumstances where a claimant makes an offer to a defendant and the defendant does not accept the offer, there will be consequences if the court awards the claimant an amount which is equal to or more than the amount of the offer. So that 90% does not apply here. It's only if the offer is as much as or more than, if the award is as much as or more than the offer. And again, in circumstances where it's not a claim for damages in any other case, if after the court makes its determination, you draw the court's attention to the offer and the court considers that the defendant was unreasonable in not accepting the offer, then there will be consequences in that circumstance as well. Now, unlike the scenario we dealt with before this, the consequences to a defendant who refuses an offer unreasonably is going to be an interest rather than costs. And that's logical because a defendant against whom an award is made will generally have to pay the claimant's costs. So the best way for us to compensate a claimant is by putting some interest consequences in play. The interest consequences are going to be generally in the discretion of the court, but the CPR provides a table which gives a guideline to the court as to what kind of interest consequences might be applicable. And that chart is on the next slide. So I am going to take you through this guideline and also point out something to you which I think might have to be changed. So before we get into this, let's just be reminded that generally by statute, the interest which will be applicable will be 2+ prime. And I think prime right now is still at 4%. So you're generally looking at about 6% interest per annum on any damages that are awarded pursuant to a judgment. But what you will find in these circumstances as a defendant who refuses a reasonable offer is that you can be paying significantly more than that. So if the net damages awarded, and again, to be clear here, the net damages refers to damages on the claim less any amount awarded on a counterclaim. And I would imagine that would also be the reverse if we're dealing with a counterclaim, net any amount which might have been awarded on the claim. If the damages awarded do not exceed $100,000, then the guideline percentage to be awarded to that party per annum of interest is 12%. So we're already looking at double what they would usually be awarded. Now that applies up to the first $100,000. For the next $150,000, you would be going down to 10%. So if you were awarded damages in the amount of $250, the first $250,000, the first $100,000, the guideline will be 12% interest, and then the remaining 150 will be 10% interest. So that covers up to 250,000. For the next 500,000, you're looking at 9% interest. So that if we are considering $750 by way of damages, the first $100,000, 12%, the next $150,000, 10%, and then the remaining $500,000 will be 9%. Now, I'm going to take note here that that gets you up to $750,000, and the next category talks about an excess of $800,000. So there is a $50,000 window here, which I think mistakenly was not accounted for. So please know that these numbers might change to take account of that gap. But for now, looking at it as it is, anything in excess of $800,000 will then be attract an interest rate of approximately 7% per annum. Again, this is just a guideline to the court. The court maintains its discretion in every respect, but you must imagine that these guidelines are here for a reason and that they might be strictly adhered to. If I can have the next slide. So this is an example of what would happen if, for example, a party was awarded $400,000 by way of damages. So the first $100,000 would attract 12% interest. And we're assuming for simplicity that the offer was made a year earlier. So we're only looking at a 1-year period. On that first $100,000, 12% interest will be $12,000. For the next $150,000, there will be a 10% interest for $15,000. And the remaining $150,000 will attract 9% interest at $13,500. So if this was an offer on the table that the defendant refused, that defendant will now have to pay interest in the amount of $40,500. And by way of comparison, if we were looking at only the 6% interest that would normally apply, that figure is actually, I did this calculation, that figure would actually only be $24,000. So you're looking at nearly double the interest. Next slide. $35.153 carves out discretion. You will note that in subrule 1 of 35.15, there was the use of the word must. And so 35.15 sub 3 gives the court its general discretion, of course, that it does not necessarily have to put that consequence in play if it believes that there are reasons why it should not be. This discretion is only carved out in relation to subrule 1 because subrule 2 uses may in relation to interest. So the discretion is built in. But in deciding whether or not to apply the rule in 1, the court will take consideration of anything that it determines that it should take consideration of, but the rules provide a list of things which the court probably should take consideration of. So that would be the conduct of the offerer and the offeree in regard to the giving or refusing of information for the purposes of enabling the offer to be made or to be properly evaluated by the person who received the offer. You will also have to look at what information was already before both parties at the time that the offer was made and the stage of proceedings at which the offer was made, as well as any terms and conditions which came along with the offer. So they're giving the court a guideline to say, listen, this is meant to guide you in the case where a person might not have accepted an offer which at the end of the day they can now see was reasonable, but which they might not have been able to really say how reasonable it was at the time when the offer was before them. Remembering, of course, that offers can even be made pursuant to this rule prior to commencement of an action. Next slide.
Ms. Clinton, if I may just let you know, you have 30 more minutes left in your presentation.
I know, I'm trying.
No, I mean, it's just yeah, that's it.
Thank you for the check-in. So 35.15 says that this rule, this part, is going to apply, as I said, to offers that were made even before proceedings were started. And this may actually help tip the scales a bit back in favor of the defendant, because, for example, if you make an offer prior to the commencement of an action, you might not have to pay any costs if a claimant unreasonably refuses it. Next slide. And lastly, for this part, 3516 deals with the amount of costs which might be determined to be payable. So if an offer is accepted, the parties are, of course, able to agree to whatever amount of costs they think is appropriate. But if an offer is accepted after the time period indicated for acceptance, or if that acceptance relates only to part of the claim, then those costs must be assessed by the court. And that is the end of part 35, which I know is quite dense. So I will pause here. Firstly, oh, sorry. I know I said that I would deal very quickly with that disparity between the 90% and the equal to or more. And in my mind, I think the reason why that is that to a certain extent, we still respect that a claimant is entitled to their day in court. And a claimant who makes or who refuses an offer, you know, when you are the person who has been damaged, you might be more passionate about wanting to fight for every single dollar. Whereas if you are a defendant and you are the one who caused the damage, and then you also refuse to accept a reasonable offer, it's almost like you've done double damage. And so I think that's why there's a bit more strictness on a defendant who refuses a reasonable offer rather than a claimant. But I, again, will allow the CJ or ask the CJ if he wishes to comment on that point or any other prior to us getting into some questions.
Yes, Ms. Clinton, well, I think you very ably covered it. It is a difficult and quite substantial part, but you've got through it extremely well. I think the 90% is simply a reflection of the fact that you don't have to hit the figure spot on. You know, that would be an unrealistic target. So if you have an offer for $100,000 and the award comes in, you know, at 10% under that, I think it just reflects the fact that it's within a reasonable range. I take your point about the defendant. There's a duty on the defendant to be reasonable, and you know, the claimant doesn't have to have the figure spot on. So I really think it's just about being in the neighborhood, and I think 10%, frankly, is what comes out of all of the other rules. So I must confess, this is not original drafting here for us. That the 90% figure is the figure that's used in many of the CPRs throughout the region. And I think it just reflects the fact that you don't have to hit a precise target, but you have to be in the neighborhood. Otherwise, I don't have any other comments. I think you've covered it very well.
Thank you. I think I was told that there was a hand raised, so I will allow that person to ask their question.
Now, I think Mr. Taylor has to enable that person's microphone. So, Mr. Taylor, can you see who has raised their hand?
Yes, sir, that would be Winder, maybe Justice
Okay.
Winder.
So perhaps you can just enable his microphone so he can.
Yes, it's been enabled. I'm just asking him to unmute. So he just has to unmute his microphone.
No, I'm sorry, that must have been an error. The presentation is very good so far.
Okay, so unless there are any other questions, and again, don't expect that this is going to be easy in this moment. You will have to take some time with it. But we're going to move on to part 36, if I can have the next slide. And here we deal with payments into court in support of offers under part 35 and under court order. And you will see that it also deals with defenses of tender. In general, this part is very similar to Order 22, but Order 22 only addresses court orders and defenses of tender. And because Part 35 is new, there are some provisions in here that specifically address payments in support of that. Also, because Part 35 had to deal with some of this, this would have come up in 35. And so you may want to kind of read Part 35 and then read Part 36 and then go back to Part 35. It becomes more clear when you take them in tandem. Next slide. So 36.1 deals with the scope of this part, which I've already indicated. It applies to support and offer payments into support and offer of a payment under Part 35, payments into support a defense of tender, and payments in with an order of the court. Just to clarify, you are not required to pay in money if you make an order under Part 35. This is just something that a party may choose to do in support of its offer, perhaps to entice another party a bit more. Next slide. Now, this is a permissive section.
Ms. Clinton, I'm sorry to interrupt, but I did just want to add this point, if I may. We all know paying money into court is not a viable commercial proposition, because when you get it out of court, you actually pay interest as opposed to getting interest. So you might just want to mention subpara 36.1 subpara 3. If you don't mind.
Yes, I think that's what I'm dealing with right now.
Oh, okay, I'm sorry, I preempted you. My apologies.
Yes, that's exactly what I was going into, because I think this is important. And it's something that parties, I think, have already been doing, but this addresses it specifically in relation to offers to settlement. So where there is money being paid in support of an offer to settle, then either with the agreement of the claimant, remembering that it would be a defendant paying in, or, you know, on a counterclaim, switch the parties, on agreement with the claimant or with the permission of the court, instead of paying money into the court itself, you can pay that money into an interest-bearing account, but any agreement or any order that you give for permission to do this must state, firstly, who the named account holders of that account will be, and any terms and conditions as to when money can be paid out of that account. You must stipulate for that. This particular rule, 36.1 sub 3, only addresses it in relation to offers of payment into in support of an offer. But the idea is that if you're getting it under a court order, then of course the court always has that discretion. I note that it doesn't refer to circumstances of defense of tender, and perhaps that is because in those circumstances, usually the claimant has already refused the funds. But I will say for right now, it is addressed only in relation to money paid in support of an offer. Next slide. So the first part of 36.2 is permissive. It says that a defendant who offers to settle the whole or part of a claim may pay money into court in support of an offer. And that just refers back to what we said earlier, that it's not required of you, but it is an option. The other two are restrictive, and they provide that a defendant may not pay money into court unless that defendant certifies that the payment is in support of an offer to settle, or if the payment is made under a court order, or if the payment is made to support a defense of tender. You may also not pay money into court until a claim is actually filed. The general idea here is that the court is not your bank. You can only really pay money in if it is supporting something. You also can't say, oh, well, I'm going to put money there because I feel like they're going to file a claim. No. Next slide. The fourth part of 36.2 is also permissive. It provides that money paid into court to support an offer can either be paid in when the offer is made or anytime thereafter if you want to further entice the party you're offering to, as long as the offer is still open for acceptance. Whereas 36.25 provides what you must do. And so a defendant who pays money into court must serve notice of the payment on the claimant, and they must file a copy with the notice and a statement of the date, if any, by which the offer is open for acceptance. And that becomes important later in terms of paying out, because the registry will need to know whether or not this money can be paid out automatically. Next slide. So now we deal with payments out, actually. And this addresses the general rule. That's 36.3. So the general rule is that a claimant who accepts an offer to settle and accepts it within the period that it was open for acceptance, or where no period is stated, accepts it before trial, is entitled to payment out of the sum automatically. They will not need a court order. In order to obtain that payment, the claimant will file a request for payment, and in that request for payment, they will certify that the offer has been accepted in accordance with paragraphs 1A or 1B above. That is to say that it was being accepted within the period stated, or that no period has been stated and it's being accepted before trial. This general rule is qualified by 36.4, which we will look at next. If I can have the next slide. We're almost at the end. So 36.4 sets out the circumstances in which you will need a court order in order to get your monies paid out to you. And the court order that is made must address the costs of any part of the claim which has been stayed by the acceptance. So in the interest of time, I'm going to ask you to just go to look at that particular rule, 36.4, and look at the circumstances in which you will absolutely need permission. But we've already highlighted that anything which is covered by 23.12, minors and patients, as well as proceedings under the Fatal Accidents Act, are going to require permission from the court. Next slide. So, one of the rules in relation to court orders, because that was the general rule previously when it supports an offer to settle. But if it is money paid in under a court order, the general rule is that it may not be paid out without the court's permission. And there is an exception if money is paid in by a defendant and the defendant decides to make that money part of an offer to settle. And we'll deal with that shortly. Next slide. So this is exactly what I said we were going to deal with. If a defendant pays money into court under a court order, but then later decides to make an offer to settle, that defendant can elect to treat the monies that were paid in as forming part of its offer to settle, or as supporting part of its offer to settle. So they would do this by giving notice that they're electing to do so and serving that on every other party. So if you're a defendant and you were made to pay, let's say, security for costs in the amount of $5,000, and you make an offer to another party, let's say in the amount of $15,000, you can give notice that, listen, I'm putting that $5,000 as being a part of my offer. And if they accept the offer, they will be automatically entitled to receive that $5,000 that was already paid in. Next slide. And 36.7 carves out some special procedures if the claim is in relation to or involves a claim under the Fatal Accidents Act. So if that is something that is in play in any claim that you are considering paying money in for, or in which you are trying to get money paid out, you will need to look at 36.7 very carefully to see what is required in those circumstances. Next slide. So I will pause here for any comment by Her Ladyship or His Lordship firstly, and thereafter to see if there are any questions on that part.
I have no comment.
No, I have nothing to add. Thank you.
I don't see any questions and we have about 15 minutes left, so I'm going to keep pushing through. The next part is part 37, which deals with discontinuance. Generally, you can refer to Order 21 of the RSC, and they are quite similar, but you should note that this part only addresses discontinuance on the part of a a claimant, we're now using. It no longer deals with withdrawal of a defense, which is actually covered under RSC Order 21, but that does not apply here. Or withdrawing an appearance by a defendant. Also know that consent judgments and consent orders are going to be covered under Part 42 at Rule 42.7, so those are also an exception to this section. And the general rule is set out at 37.2, which is that generally a claimant can discontinue an action against any or all other defendants without the permission of the court. But there are some circumstances in which permission is needed. Those are listed on your slide here, and I would advise you to go and have a look at 27.2 sub 2 as to the exceptions to that general rule. Next slide. 37.3 sets out the procedure. Notice of discontinuance must be served on every other party, and a copy of the notice must be filed certifying that it was so served. And attached to that notice, you will have to attach any consents that were necessary for you to discontinue the action, and or the order, the details of the order if permission was necessary for you to discontinue. Under 37.4, if notice of discontinuance is served and they required permission from the court but did not obtain it, then any party who is served with that notice can apply to set it aside within 28 days. But at 37.5, we see that the effect of discontinuance is immediate. It takes place from the date of service of the notice. But of course, that effect does not affect any proceedings in relation to costs or any proceedings to set aside a notice which ought not to have been served. Next slide. So the general rule is that a claimant who discontinues against a defendant is liable to that defendant for the costs of the claim or any part of the claim that's discontinued. But of course, the court still has a discretion, so the court may otherwise order or the parties can otherwise agree. If only part of the claim is discontinued, then much like what we discussed earlier in terms of part settlement, those costs will have to be quantified and paid at the end of the action. Next slide. So that general rule is qualified by 36.4, which sets out circumstances in which the court must give permission or a court order must be obtained prior to you. Sorry, making sure I'm in the right section. Sorry, yes, sorry, this is a protective measure. I was looking at the wrong thing. Can I go back one slide, sorry? Yes, sorry, 37.8 is a protective measure. So where a claim is discontinued against a defendant, as we said, they are to be quantified at the end of the claim. And that's for the same reasons, to allow a defendant time and to see how the rest of the claims pan out before he has to start paying on those costs. Now I can go to the next slide. This is the end of part 37. So again, I'll pause here for any questions on that, but I will say that there's not much deviation between that part and RSC Order 22. Okay, so very quickly, we're going to deal with part 38, which is addressed towards pretrial review. Again, this is a section with not much deviation from the rules of the Supreme Court. Generally, it is to be held shortly before trial if the court so orders. The court has to consider at every hearing from the PTR up until trial whether or not a pretrial review will be helpful. but a party can apply for a pretrial review so long as they make that application at least 60 days before the trial date. And the court office has to give each party at least 14 days notice of a pretrial review. The case management rules still apply to pretrial review, and I think case management was covered in an earlier session. And wherever practicable, pretrial review should be conducted by the trial judge. Next slide. Something that you should take note of in 38.5 is the parties must seek to agree a pretrial memorandum. That memorandum must be served 7 days before the pretrial review where it is agreed, or if it's not agreed, each party must file their own 3 days before the trial. There's some similarities between this part as 31A, particularly 31A Rule 29, which sets out what is to be included in that pretrial memorandum. And so you should look at both 35.5 as well as the rules of the Supreme Court to familiarize yourself with that. At the pretrial review, a judge must give directions, and those directions must ensure the fair, expeditious, and economic trial of the issues. Some considerations that the judge should look at are listed under 38.6. And again, this is very similar to the provisions under Order 31A of the RSC. Next slide. So that's pretrial review. As I said, it's very similar to what we already have, so I didn't intend to spend much time on it unless someone has a particular question. Okay, so part 39. This is dealing with documents for use at trial. 21 days before trial, the parties should inform the claimant of documents that they wish to include in the bundle. And I've started.
Oh, okay. Take care. You the last one? Okay.
I've started calling this a document bundle, even though that's not the terminology used in the CPR, and you'll see why. So the claimant, once they hear from the other parties, is going to prepare a paginated bundle, and that bundle has to include everything that the other parties asked to be included, but it will separate out those documents which were agreed for inclusion and those documents which were disputed as to whether or not they should be included. And in the usual way, there can be costs in relation to those disputed documents later. 10 days before trial, a claimant must file a fuller bundle, which is going to include that documents bundle, but which also has certain pleadings which must be included in there as well. I'm going to draw your attention specifically to 39.1 and to look at everything that must be included in that bundle. If that bundle exceeds 100 pages, then you will also have to produce a core bundle. And the core bundle is only going to include the documents which you expect the judge will need to read before the trial, or documents which you expect will need to be referred to repeatedly. So for example, if you have a claim in which the main issue is interpretation of a contract, the contract itself is going to need to be in your core bundle. And in the usual way, where only a counterclaim is being tried, then claimant here will refer to the counterclaimant. Next slide. The court has the power to limit cross-examination, which it always has. With consent of the judge, the parties can file written submissions instead of or in addition to closing speeches. But if you're going to do written submissions, they must be filed 7 days after the trial or some other period as the judge might fix. This is only to emphasize that, the CPR is very particular about timelines. So instead of it being open-ended, generally you should expect that those submissions will need to be in within 7 days. If the court is satisfied that notice was served on an absent party, the court may either strike out the claim or continue the claim or continue the trial, I guess I should say, in their absence. And that is already the case. And the court may apply to set aside a judgment or order, a party may apply to set aside a judgment or order made in their absence, but they must do so within 14 days of service, and they must support their application with evidence, not only as to why they were not present, but also that some other order might have been made if they had been present. Next slide. And 39.6 and 39.7 provide that a judge may adjourn a trial, but the judge may only adjourn a trial to a fixed date or to a date that would be fixed by the court office. Again, this emphasizes the desire to not have anything adjourned sine die. We're trying to make things move quickly and efficiently. So fixed dates tend to help the parties to do that. Also, it retains the general power that a judge may inspect any place or thing relevant to any issue arising in the claim. So that is the end of part 39. And I think there was one question. Would it be fair that section 39.1 is a requirement for basically the same or substantially the same bundle of documents twice? Cost. There are some distinctions, and remember the core bundle is only going to come into play if you have a general bundle that is over 100 pages. The intention is to make it easier for the parties in the course of the trial to keep track of all of the evidence that they'll need to refer to rather quickly or very often. This is not very different if any of you have prepared for an appeal to the Privy Council. The same way that you have kind of the bundle that goes to the local court, and then there's a reproduced bundle, and then there's a consolidated bundle, and then there's a core bundle. It does mean a lot of paper, but as we are doing right now, I will say that most of my actions, we have been using electronic bundles. So not necessarily going to be a lot of paper if we continue under that same practice, so that you can have an electronic documents bundle, an electronic kind of fuller bundle, and electronic core bundle. But I will say that the Chief Justice is probably the best person to speak to that.
No, I think you've answered it very well. This is to, it's in effect a smaller bundle, which is more manageable. And in fact, I think it does benefit the parties, because it's unlikely that the judge is going to read hundreds of pages. And so if your core bundle is, if your first bundle is more than 100 pages, all you're doing is providing a more manageable bundle, which the judge is likely to read. So there may be some duplication, but I think it's well worth it. And as Ms. Clinton said, a lot of this is going to be done electronically going forward. So I don't think it should escalate costs to any significant extent.
So I'm very aware that it's 7 o'clock, but there are only 5 slides left. So if you'll bear with me, I will get through them quite quickly because there's not much difference in the rest of this. If I can have the next slide. So part 40 addresses the appointment of a referee to inquire and report. 40.1 provides, and again, we've highlighted in red those parts of the RSC which come into play in the formulating, I guess, of part 40 of the CPR. 40.1 provides that a court may order a claim or issue to be tried by a referee in circumstances where either the parties, where the parties agree, where the claim requires prolonged examination of documents or scientific or local investigation which cannot conveniently be carried out by the court, and where the matters in dispute are wholly or mainly of account. Next slide. The court may refer any issue or question of fact to a referee for inquiry and report. As a general rule, that referee or appointee must be appointed at case management unless there's some good reason why it comes about later. The referee must be agreed by the parties, but if the parties cannot agree, the court will appoint based on either a list provided by the parties or some other manner as it directs. The court must specify the question or issue which will go to the referee. They must also at that time decide what fees will be paid to the referee and by whom, and know that that first order to say who will pay the referee is an interim order, and then there will be a final determination on conclusion of the claim as to who should actually be responsible for those costs. The court can also revoke an appointment or appoint another referee at any time on an application of a party or of its own motion. Next slide. Under 40.4, The referee has the same powers as the court, save that the referee is not able to deal with committal for contempt of court. Unless the court otherwise orders, the referee must adopt the simplest, least expensive, most expeditious, and just means of conducting the reference. That reference can be in person or via video conference, and it can be at a time and place that is convenient to the parties, taking into account the issues above, keeping it least expensive. And of course, remembering the witnesses' summonses, which were addressed by Her Ladyship, where a summoned witness fails to attend or refuses to be sworn or affirmed or refuses to answer any question or produce any document, the referee may sign and file a certificate of such refusal or failure, and thereafter you will have to apply to the court for enforcement. I would advise you to go and look at 40 particularly, because it addresses some of the consequences that might be suffered by a witness who refuses to attend or who refuses to answer any question. There are some cost implications potentially for that witness. Next slide. The report is to be made to the court, and copies will be supplied to each party. A referee can submit questions to the court if they have any questions in relation to what exactly their report should cover. And they can also make a special statement of facts from which the court may draw inference. And I think that that refers back to the fact that the referee can comment on the conduct of any party who attends the reference as well. That's something that if you go back and look at 40 in greater detail, will flag up to you. On receiving the report, the court must fix a date to hear the parties, and they must give the parties at least 21 days notice. After hearing the party, the court has wide powers as to whether it will accept the report, whether it chooses to vary the report, reject the report, remit the report back for further consideration, or to say that only part of it will be admitted for trial purposes. And lastly, in proceedings against the Crown, the referee may not be appointed without the consent of the Attorney General. That is the end of part 40, if anyone has any questions. Okay, and this is our last slide. It's part 41. As I said, part 41 is very similar to order 43. You can line them up side by side and you won't be taken very much by surprise at all. All I'm pointing out to you is that an application can be made in an existing action, or where no existing action exists, you can take out a fixed date statement of claim supported by affidavit evidence if all you are seeking is accounts and inquiries. And I think an earlier session should have dealt with fixed date statements of claim. This section also addresses trial of preliminary issues, and the court must give directions on how the account or inquiry is to be taken. Unlike in the RSC, the accounts must be served on every other party unless the court otherwise directs. So that's just something to take account of if you are the person or representing a party who is ordered to give account or to be party to an inquiry. Otherwise, I would just say go and look at this part, and as I said, compare it to Order 43, and there shouldn't be much difference. So unless there's any questions on this part, I will refer back to His Lordship.
Well, thank you very much, Justice Donald Gomez and Ms. Grinton. You certainly have covered a lot of material, and if I may say so, you've covered it very well. It's been instructive and informative. There's a lot of work that's involved in these presentations, so I thank you for taking the time to do that. The hour is late. Are there any final questions before we sign off? If so, you can indicate now. While you're doing that, let me just remind you of two things. The next session, the CPR training session, is scheduled for the 13th of April, which is next week. That session will be taken by our colleagues at CASIO. So I hope that you put that in your diary. I would also, you'll be getting the usual notices and links, but please enter that in your diary and see if you can be with us on that occasion. Also, we would remind you to please fill out the evaluation form that either has been sent or will be sent to you. That feedback is very useful for both the panelists and also the organizers. And we try to be responsive to any suggestions that you have in terms of how we can improve the presentations or deal with issues that we haven't addressed. So please take the time to fill out that evaluation form. And the final point I will remind you of is that this session, which has been packed with information, and the very comprehensive and helpful slides will be posted on our website, certainly by the weekend. So if you need to go back and study some of these things more carefully, as I'm sure you will have to, you'll find it's all there on our website. I must say I've heard from a number of lawyers, and they have commended the recordings and the slides because they can go back and take their own time and they can study it. And so I hope this is helpful, and this presentation of the slides will be posted by the weekend. So you'll have some time to look at it a bit more carefully. So on that note, I thank our panelists again. I thank all of you for taking the time to join us, and I bid you all a very good evening.
Good evening, all.
Good evening.